New 2025 visa crackdown. Travel, renewals, and reentry rules set to tighten. A major White House review is quietly shifting the entire visa landscape, and immigrants may soon face significantly tougher travel, renewal, and reentry rules than expected. This emerging late 2025 proposal is gaining momentum behind closed doors, and early indicators suggest potential consequences for workers, families, green card holders, and long-term residents navigating essential immigration processes. As agencies prepare internal guidance, the coming months may redefine how trusted pathways function and how stable lawful permanent residency practically feels for everyday immigrants. The emerging proposal. Senior officials recently confirmed that President Trump's team is actively reviewing an executive action targeting specific visa categories while expanding reentry scrutiny for certain lawful permanent residents. Although no public memorandum exists yet, federal agencies have begun preparing internal checklists, operational instructions, and procedural workflows that signal an imminent policy rollout. The proposal appears narrower on paper, but may trigger broader consequences by restricting short-term mobility, slowing visa renewals, tightening interview standards, and increasing overall security layers. This approach mirrors older bans but introduces additional elements, including country-specific restrictions, enhanced security reviews, and new documentary requirements tied directly to visa renewals. What the proposal could do. Early indicators suggest the policy aims to reduce visa flows, extend review timelines, and introduce additional friction across both non-immigrant and immigrant processing channels nationwide. Applicants may face more requests for evidence, prolonged consular queues, delayed interview scheduling, and extended review cycles for even routine documentation historically considered straightforward. For some green card holders, extended international stays, unclear ties to the United States, or visits to sensitive regions may trigger secondary inspections or temporary entry holds. H-1B, L-1, and F-1 travelers may encounter reduced stamping appointments, stricter renewal standards abroad, and heightened eligibility scrutiny during post-travel processing. Meanwhile, immigrant visa applicants waiting through consular channels may see pauses, reassessments, or temporary holds depending on security factors associated with designated countries. Why this matters. Between 2018 and 2020, similar administrative actions doubled or tripled wait times in several consulates, creating major travel disruptions for families and employers worldwide. Consulates that once scheduled interviews within 3 months eventually required 9 to 12 months, producing lengthy separations and extended backlogs for affected applicants. If repeated now, professionals relying on international travel may face threatened job opportunities, unstable project timelines, and unexpected risks associated with routine visa stamping trips. Families dependent on consular interviews may experience added months or years of separation, especially where limited financial resources constrain travel flexibility or relocation options. Green card holders balancing international responsibilities could face unpredictable reentry obstacles, complicating employment stability, medical obligations, or caregiving duties for children and parents. The hidden mechanism. This proposal's true impact lies in its administrative structure, allowing agencies to alter operational standards without Congress passing new legislation or advancing public debate. Procedural adjustments can shift interview frequency, security layers, document expectations, and consular scheduling without ever rewriting the underlying law governing visa eligibility. By combining country restrictions with administrative tightening, agencies can significantly reduce approvals or delay movement without issuing any explicit long-term bans. This mechanism is harder to challenge legally because it operates through internal agency discretion, not through legislative reforms or sweeping statutory measures. These changes effectively create de facto immigration policy shifts that transform the system quietly, gradually, and with limited avenues for immediate public accountability. Who gets hit first? Frequent travel H-1B professionals may face the earliest disruptions, as unpredictable stamping delays could interrupt project cycles, contract obligations, or time-sensitive work responsibilities. Family-based immigrant applicants living abroad may observe immediate appointment slowdowns, especially in consulates where country-based restrictions influence case prioritization and officer availability. Green card holders dividing time between countries or supporting relatives abroad may encounter elevated scrutiny during reentry, potentially complicating plans for essential visits. Employers may face rising compliance burdens, possible staffing shortages, and expanded documentation requirements, especially for industries relying heavily on foreign technical or managerial expertise. Lower-income sponsors and petitioners may struggle with increased financial verification rules, placing additional stress on families already navigating demanding evidence requirements. A real-life example. Consider an H-1B project manager commuting between California and Manila whose visa renewal becomes temporarily restricted due to country-specific screening requirements. A sudden delay forces missed deadlines, postponed contracts, and compromised project milestones that directly affect employment status, client relationships, and organizational performance. Meanwhile, her employer must restructure tasks, renegotiate timelines, and absorb financial loss created by external visa complications beyond their operational control. This example demonstrates how administrative adjustments at the federal level can ripple through family planning, economic stability, and long-term career growth. What this means for you. Travel-dependent workers must reconsider international plans because even routine trips may face delays that risk employment continuity or immigration status stability. Families awaiting reunification through NVC or embassy channels could encounter extensive delays that reshape financial planning, educational timelines, or long-term settlement goals. Green card holders responsible for elderly relatives abroad may need to modify travel expectations because unpredictable reentry procedures could compromise caregiving duties or essential obligations. Understanding these adjustments now helps you avoid future vulnerabilities created by rapidly shifting administrative environments and evolving governmental priorities. Steps you should take now. Delay unnecessary international travel until official publication confirms the scope, details, and implementation timelines of the proposed executive action. Organize stronger proof of U.S. ties, including tax records, employment documents, lease agreements, school enrollment letters, and updated supporting evidence demonstrating your continued presence. Monitor embassy accounts, USCIS profiles, and NVC portals consistently to respond quickly when document requests or interview scheduling changes appear. Employers should conduct internal audits of visa-dependent roles, prepare backup staffing plans, and consult immigration counsel to avoid major operational disruptions. Families separated across borders should document communication history, financial support, and relationship evidence meticulously to strengthen their case during potential delays. Legal landscape and court expectations. Previous executive actions generated immediate litigation, producing nationwide injunctions, partial suspensions, and ongoing legal uncertainty affecting thousands of pending applicants. Similar legal challenges may emerge again, yet court timelines progress slowly, meaning temporary enforcement windows can still create significant harm before final rulings. Congress may debate executive authority limits. Although legislative action often lags behind urgent immigration realities and requires sustained political cooperation rarely seen today. Administrative processes, however, operate quickly, quietly, and with narrower public visibility, giving agencies greater influence during periods of evolving immigration priorities. Why you must prepare now. Small procedural revisions often become major delays because every added layer introduces new cues, bottlenecks, and discretionary checkpoints that slow processing dramatically. Travel disruptions can jeopardize employment, educational planning, caregiving responsibilities, and financial stability for immigrants depending heavily on predictable mobility. Understanding the emerging landscape now allows you to take proactive steps that protect your status, strengthen your evidence, and reduce future uncertainty. If you found this update helpful, like, subscribe, and turn on notifications so you never miss critical developments affecting your future in the United States.